Hello, dear friends. In this series of lectures of the ecclesiastical law for the students of Erasmus program, we'll speak about church and state relations in Greece and in other European countries. The Article 13 of the Greek Constitution concerns religious freedom. In the first paragraph, we read, "Freedom of religious conscience is inviolable. The enjoyment of civil rights and liberties does not depend on the individual's religious beliefs." Now I explain this paragraph and then the subsequent one. The paragraph 1 concerns the freedom of religious conscience or the freedom of religious beliefs. The freedom of religious conscience is inviolable, means that freedom or freedom of religious beliefs cannot be subject to any limitation. This freedom is unlimited. Because for the law, there are not correct or non-correct beliefs, religious or non-religious one. For the law, there are not true or false beliefs. For the law, there are not mainstream religions and heretical religions. There are not heretical beliefs for the law. For the law, there are not sects. The term sect is a term, a political term, and it does not express a respect for a religious group. For the law, there are only individuals who have beliefs, either religious or non-religious one, as they characterize them on the first level, because on a second level, that is, when a state gives some prerogatives only to some religions, there can be a legal definition of religion. For the law, all the religious groups which claim that they are religious one enjoy their freedom of religious conscience or religious beliefs. The second subverted of the same paragraph 1, the enjoyment of civil rights and liberties does not depend on the individual's religious beliefs, contains the principle of equality and non-discrimination. Either the freedom of religious conscience or the principle of equality and non-discrimination are protected also not only by the Constitution but also by the international law of human rights on the ecumenical level, and that is on the level of the United Nations, and on a regional level also, and for Europe or European level. The principle of equality and non-discrimination is applied in conjunction with a subjective human right, that is, religious freedom and principle of equality and non-discrimination. Paragraph 2nd of the Article 13. All known religions shall be free, and their rites of worship shall be performed unhindered and under the protection of the law. The practice of rites of worship is not allowed to offend public order or the good usages. Proselytism is prohibited. This paragraph 2nd concerns the so-called known religions. The term known creates problems, as the special rapporteur on religious intolerance and now on religious freedom has indicated in his report for his visit in situ in Greece. A group which claims that it is a religious one is not under examination if it has genuine or non-genuine religious beliefs, because the law is incompetent to examine if certain beliefs, religious or non-religious one, are genuine, are correct, are true. The law is totally incompetent to examine all these matters. From the moment a group which claims that it's a religious one says that it is a religious one, it enjoys its religious human rights, among them the right to religious freedom. The term known religion, used in the Greek constitution, means, according to the case law, of the Council of State, that is of the Supreme Administrative Court of Greece, that it has known doctrines and known practices for the public. There are not secret doctrines or secret practices, totally or partially. In the past, that is before 1975, when the Council of State recognized Jehovah's Witnesses as a known religion, the scholars, constitutional and ecclesiastical one, and the case law said that this term, known religion, meant the religions which first did not have secret doctrines or secret practices, and second, that those religious groups do not have any doctrines or practices contrary to the public order or public morals. But the second condition for this term known religion was deleted by the case law of the Council of State in the case of Jehovah's Witnesses of 1975. The paragraph second of the Article 13, except the proclamation of the freedom of the so-called known religions, it recognizes the freedom of worship of the so-called known religions. In this way, not all the religions enjoy freedom of worship, but only the known religions. This creates a problem of conformity of this second paragraph of the Article 13 of the Greek Constitution with the international law on human rights, which recognizes the freedom of worship as a special form of the right of manifestation of religion or belief. For all the religions, not only for the so-called known religions, so-called by the Greek Constitution. And in the theory, legal theory, it is said that this term non-religion does not impose a recognition procedure for the religions. Of course, there is not a formal, official procedure for the recognition of religion as in other countries. But this term, known religion, is examined during more procedures. That is, when a religious group submits an application to the Ministry of Education and Religions to gain an authorization for the building or the function of a temple or a house of prayer. Also, this term non-religion is examined in another procedure, that is, when a conscientious objector says that he belongs to a known religion which has beliefs contrary to war and contrary to the military service. This term non-religion is examined by the special, in this case, this term is examined by a special commission of the Ministry of Defense, which examines if a conscientious objector has genuine conscientious objection to military service. This term, known religion, is examined also in other procedures. When the Ministry of Finance examines if a group which claims that's a religious one has a right to a tax exemption according the tax legislation in force. The term known religion is examined also when a religious group submits an application to the competent court to acquire legal personality of a common association with a religious aim. And recently there is also another procedure under which the term no religion is examined. That is when a religious group submits an application to competent authority to acquire legal personality of a religious legal person or ecclesiastical legal person according to the law 4301 of 2014. The second verset of the same paragraph second of the Article 13 gives two limitations to the freedom of worship, that is, public order and good usages. Better term for good usages is public morals. As it is known, these limitations constitute also limitations of the of manifestation of religion or belief under the international law of human rights also. But as it is also known, there are other three limitations, legitimate limitations under international human rights law. Public safety, public health, and rights and freedoms of others. Public order means all the basic principles under the Constitution which are necessary for the order in the society, and public morals means public morality, which must come not only from one religion, as the general comment number 22 of the Committee on Human Rights of the United Nations say, but public morals must come from many morals existing in a society, many religious or non-religious morals. And the verset 3 says that proselytism is prohibited. The term proselytism in the Greek constitution is also a problematic one, because proselytism in the international literature means the teaching of religion, the legal teaching of religion. The best translation of it would be proselytization is prohibited. Proselytization has a negative meaning, and if we have to search for its correct, from a legal point of view, meaning, we can say that proselytization means the exercise of the teaching of a religion in a manner which is not accepted by the law. In a manner which is contrary to the law. But what law? Of course, to the law which is on the top of the hierarchy of the laws, that is, to the Constitution and to the international law on human rights, but the term proselytism, or better proselytization, is incorporated in the Constitution. So, this term, it has to be interpreted according to the international law on human rights. In the international law on human rights, we meet that the teaching of religion is a form of manifestation of a religion or belief. And when the freedom of manifestation is against the international law on human rights, it is against the national law on human rights when it is contrary to another freedom recognized by the international law on human rights. What do we say about the international law on human rights? It is valid also for the constitutional interpretation of the relative dispositions. The only acceptable meaning of the term proselytism or proselytization. Acceptable means that this interpretation does not violate the substance of the freedom of teaching. The only acceptable interpretation of the term proselytism or proselytization is that the teaching of a religion must respect the freedom from coercion, psychological coercion or physical coercion, according to the paragraph 2nd of the Article 18 of the International Covenant on Civil and Political Rights. Concluding the interpretation of the paragraph 2nd of the Article 13, we have to say that the term known must be considered as not written in the Constitution, because it is contrary to the international law of human rights. The Council of State and the scholars have interpreted the term known, have tried to interpret the term known, but not the term religion. We have to try to give a legal definition of religion. Thank you very much for your attention.